Right, I think let's get started. Good evening, everybody. Good afternoon, depending on where you are. Welcome to our webinar, the first of this year. Going to be a very interesting year, filled with all kinds of interesting changes and a lot of world events that will impact immigration. We'll try and guide everybody through it as best we can. This evening, I have the pleasure of having three colleagues of mine with me, Verity, Kiara, and Dirk, who will each take turn to do a short presentation for us, after which we'll take Q&As. Please, any questions you ask them in the Q&A function, not on the chat function. It just makes things a little bit easier for us to manage. We'll try and get to as many of the Q&As as we can. If we don't get to a Q&A, please feel free to email us, info@bic-immigration.com, and we'll be very happy to get back to you. So to get us started this evening, I'm going to hand over to Verity, who's going to regale us with the newest changes and procedures pertaining to the skilled worker route. Verity, over to you. The rest of us are just going to mute and close our windows so we don't distract anybody. Thank you.
Lovely. Thank you, JP. So yes, as JP said, and I'm sure many of the people joining today have seen plenty of announcements coming in from the Home Office over the past couple of months. In particular, today, I'm going to focus and just spend about 10 minutes just running through the key changes that have been announced in the points-based routes. So that's skilled worker visas with a little bit of extra focus on the health and care route. And then also just some comments on the changes to the student visas and some positive news that we have about returning resident applicants. So quite a lot to cover. As you'll see, though, and it's important, I think, to bear in mind, the media can be very misleading when they are reporting these changes. So hopefully this will help to bring a little bit more clarity. So what we know so far, and I'm going to start with the skilled worker visa updates. Just to stress before I do this, these changes have not yet made their way through Parliament. At the moment, despite anything you're seeing the media reporting, these are not set in stone. They haven't come into force. They still need to go through parliamentary process. So, of course, everything that we're saying today is just what we know so far, and it could change as things work their way through the Houses of Parliament. So first of all, probably the one that everybody has heard is that the minimum basic salary rate for all skilled worker visas, apart from some exceptions, which we'll go on to in a moment, is due to increase to 38,700 per annum. And so far as we understand, that's going to be a base salary requirement, a gross base salary requirement. Obviously, it's quite a lot higher than the current figure, which at the moment is 26,200. It actually, though, realistically pulls us back a bit closer to what the rules were like pre-Brexit. So although it's very shocking, quite a steep increase from what we're used to over the past 2 or 3 years, it's actually very, very similar to what we were seeing before the UK left the EU, and we dropped the salary rates down quite fundamentally at that point. The other good news is that we are going to have some, or at least we've had some announced exceptions to those. So we have the health and care visas. We know very clearly announced that those are going to be exempted from that. And I'll speak a little bit more about what we know on the health and care visas in a moment. Also the national pay scale occupations. So by and large, that's talking about education positions, teaching positions all the way through from primary school to higher education. Just to note, I can see, Ahmed, that you've raised your hand. If you wouldn't mind, as JP mentioned, just popping your question down into the Q&A section, and hopefully we'll get to that a little bit later on. Thank you. Then this immigration salary list. So as you'll see below, the shortage occupation list is going to be replaced by this immigration salary list. We don't know exactly what positions are going to be on there or how that's going to work. It is something that's under review by the Migration Advisory Committee at the moment. There is absolutely potential for that list to be quite far-ranging, so we're all very excited to see what that's going to say. We may even find that it provides a wider scope than the current shortage list, especially in light of the fact that the Home Office has added additional occupations to the shortage list in recent months. So far as we're aware at the moment, the Home Office is targeting to bring in these changes around the 4th of April 2024. That'd be in line with the start of the tax year, which is usually when we see these spring changes coming in. Again, that date could be pushed back. We've already seen that happening recently with things like NHS fee increases ended up coming into place quite a bit later than expected. So, all of this is not set in stone. The other bit of good news is, so far as we're aware, from what the Home Office has released so far, is that anybody who's already here on a skilled worker visa hopefully shouldn't be impacted by these changes, and should be able to continue on their normal salary rates that they were being sponsored on previously. So just to move along to the health and care visa and just focus in a little bit more on that. As I mentioned on the previous slide, the announcement states that all health and care positions are going to be exempt from this 38,700 per annum salary cap, which is great because a lot of care workers particularly don't earn at those sort of levels in the UK. Again, we don't know for sure, but it is likely that the salary rates will just stay imposed in line with the NHS bandings. That includes if you're coming to work in private practice. Care work positions are also remaining eligible for sponsorship. And you'll see as I go on that there's some not great news about the changes to these sort of care workers, senior care workers, less senior care workers, care support workers, and so on. But I do have to emphasize, when the Home Office introduced the care workers into the immigration route and allowed them to become eligible for sponsorship early in the 2020s, it was actually only expected. They announced at the time that would come in for 1 year only. So albeit the information that they're announcing now isn't fantastic, it is absolutely a lot better than them having just removed potential for people to bring across, senior care support workers and so on. As I say, unfortunately, on the flip side, these announcements do show that at the moment, carers who offer unregulated services are able to get the visas. That is changing. The Home Office is only going to allow this for care providers with CQC, that's Care Quality Commission regulation. From what we see, it probably won't impact too many of the providers. Most of them do have that regulation, but there certainly will be a few care providers that will be impacted there. Likewise, and one of the big ones that's being quite highly announced, carers and care workers, the Home Office is planning to make it so that they are no longer allowed to bring family members, that being spouses, partners, and children under the age of 18, to the UK as their dependents. The target date for this and the CQC regulation, we are told, is the 11th of March of this year. Obviously, that is just around the corner. So they may rush it through in time for that, but I wouldn't be surprised to see that being pushed back a little. Again, as is often the case when these changes happen, people who are already here, who already have dependents attached to their care worker visa, may remain. There are indications, though, that people who are perhaps here on a different kind of visa status, maybe as a student with dependents attached to that visa, may not be able to bring the dependents across to the skilled worker visa route with them. So again, something we'll need to check and provide further information on as we see more information coming out. But that point hasn't been made entirely clear. Some good news, though, it is the other health and care positions, so far as we're aware, still will be able to bring dependents. So far as the Home Office has announced, this is only carers and care workers that are going to be impacted by this restriction on dependents. From our point of view, there's definitely still going to be a large portion of people who can find this route viable and attractive, even without the dependents, even with the requirement for CQC regulation. In particular, I think this will remain a very, very viable route for younger migrants who don't yet have family ties looking for a way to get to the UK. Just to move on to the student visas, so not as many updates here, and some of the information not quite as well established. What we do know is the graduate visa route, which is also sometimes known as the post-study work route. Now that actually had been done away with in the 2010s and was only reintroduced in 2020, I believe it was. So really, they've only brought it back for about 3 years, only to start considering possibly removing it or adapting it again. At the moment, though, this is really something that is just in discussions. The MAC report, that's Migration Advisory Committee, is only expected later this year. So chances are we won't know any more about these changes or what's going to be happening or what they're going to look like until later this year at the earliest. Again, there were changes already made to the student visa route at the beginning of this year. That now means that they too have restrictions on the number of dependents they can bring. From now onwards, it is only PhD, i.e. postgraduate research courses, students who are going to be able to bring dependent family members or courses where there's been this grant of government-funded scholarships. Any lower sort of level studies or non-government funded scholarship studies no longer can attach dependents. Dependents who are already here, again, can remain on their visas. Finally, in sort of a kind of crossing over of the two routes that we've been discussing, it's very important both for student migrants living in the UK who are planning to at some point to move on to the skilled worker, or for anybody who might be joining us today who's from an organisation that sponsors workers. Up until recently, it was possible for a student visa to switch over onto a skilled worker visa at any point in their course. They technically didn't even need to have started. Under the new rules, anyone looking to switch over from a student visa will need to either have completed the course successfully or be very close to completing the course, and with a caveat that if the course isn't completed successfully, the sponsorship will need to be ended. So again, it's further considerations to take into account if you're looking to transition from one visa to another. Funnily enough, there doesn't seem to be anything in the rules preventing people from leaving the UK and applying for entry clearance, but the Home Office may well legislate to close that loophole in the near future. Finally, just to bring everybody a little bit of good news, and again, this is very provisional. These changes have come into place, but they are very, very new. The Home Office guidance has not yet been updated. So at the moment, we are advising on the basis of what we understand these changes to mean, but I would very much urge anyone who's interested in this route to get in contact so we can discuss it further, because this is very new and not yet tested with the Home Office. Just very briefly, to give a very quick background here, anybody who holds indefinite leave to remain, historically speaking, could stand to lose that status if they left the UK for a period of 2 or more years without returning for resettlement. When the Home Office says for resettlement, what they mean is they're not talking about you just popping in for a quick visit. You have to have within that 2 years returned with the intention of settling in the UK, living in the UK again, not just popping back for a quick visit. These rules have recently been updated, and as I say, it is very, very new, but the changes suggest that under the new rules that this ILR status is settled status might be maintained even if you are just visiting the UK within that 2-year period, meaning that you can just maintain that status by popping back and making sure you're not being absent for more than 2 years. So I say, very important, if you're planning to rely on this, do speak to us first when we've got a bit more information. There's also further indication. Previously, if you had left the UK and not returned for 2 years, it was pretty difficult to get your status reinstated to come back as a returning resident. You had to really show some sort of extenuating circumstances for why you hadn't been back in the UK and so on. Now, one of the provisions in the rules has been removed, which very much suggests now that actually if you've left the UK, even for more than 2 years, even if you've not stepped foot in the UK for more than 2 years, then you may still be able to reclaim your settled status. You would need to make a returning resident application from overseas, but it seems that that application would be viable provided you left the UK last under your own cost, i.e. you didn't use any public funds to leave, and 2, that you can demonstrate that you have maintained some strong ties to the UK during the absence. Until we get the guidance, we don't know exactly what they mean by strong ties, but it's reasonable to expect that business interests, family members, financial holdings, property, things like that would all likely be taken into account. As I say, still very new news, but it was quite an exciting point and can be very beneficial for some of our clients who are worried they've maybe lost their status here. So we just wanted to highlight that. So I'm going to pass you over to Chiara now to carry on with the next set of topics.
Thank you, Verity. So let me just share my screen. Okay, perfect. So good evening, everyone. I'm going to cover the latest developments in the EU settlement scheme and touch upon the legal remedies available when a decision is refused or rejected. Okay, so as many of you may already know, the EU settlement scheme is a scheme introduced in March, on 30th of March 2019, to protect the rights of residents of nationals of the European Economic Area and their family members after Brexit. So the scheme is open to nationals of the EU countries, Switzerland, Norway, Iceland, Liechtenstein. We are now referring to European, I meant to European nationals, but they are nationals of the European Economic Area who were already living in the UK before Brexit, okay? And family members already living in the UK before December 2020. It is surprising to, you might be surprised to hear that the settlement scheme is actually more generous than the withdrawal agreement, the Brexit agreement, because it doesn't require applicants to be financially active in the UK. So, but only to have resided in the UK. So a French national who was living in the UK in January 2020, for instance, will be eligible, will have been eligible to apply under the scheme. The deadline to make an application was the 30th of June 2021. Different deadlines apply to other categories of people, like joining family members, for instance, family members who arrived in January 21 or will arrive later. Who is eligible to apply under the scheme? So, as I mentioned, all nationals of European Economic Area nationals and a family member already living in the UK before 31st of December 2020, unless they had a serious criminal history. If these people have lived in the UK for 5 years, they could have applied for settled status directly. Settled status is the same as indefinitely to remain, permanent residence. So someone, a French national living in the UK since 2015 or 2014, will have easily applied for settled status. Where the person had not lived in the UK for 5 years, they were eligible to apply for pre-settled status, which is basically a 5-year visa, and which can be upgraded to settled status once the person accrues the 5-year period. Continuity of residence is broken by an absence of more than 6 months in any continuous 12 months period. This means that if someone, a French national, came to the UK, let's say in 2015, but then he left for 1.5 years, that person will have not been able to apply for settled status immediately. So he will need to wait until the 5-year period clear from absence is reached. There are exceptions to this rule. For instance, absences due to unimportant reasons, which do not exceed 12 months, or COVID-related absence are accepted by the Home Office. So the person will still be able to apply for settled status. Any applications made after 30th of June 2021 are considered late applications. And failure to apply will have very serious consequences because the person will have been an overstay, will have become an overstayer. And unfortunately, we have many clients who did not even realize to have become overstayers. Becoming an overstayer entails losing right of residence, right to work, right to rent. So it's an extremely serious situation if someone has failed to apply before or by the deadline of 30th of June 2021 and has not submitted a late application. Late applications are permissible where the applicant has a valid justification, so reasonable grounds for applying late, for missing the deadline. The good thing maybe if there are tonight amongst you European nationals, family members who submitted an application, even an on-time application, will know that on receipt of a valid application, the Home Office will issue a document called Certificate of Application. It's a document they sent by email. And this document is very important because it offers temporary protection to the applicant while the application is pending. So allows a person to work, to use NHS, to apply for a driving license. Following changes to the immigration rules in August and then again in October, the Home Office policy guidance on the EU settlement scheme has changed drastically, has changed its approach towards late application. In September alone, last September, almost 14,000 applications were rejected as invalid, up from an average of 1,730 applications per month. So you can see the sharp increase in rejection of applications. That's a data reported by ILPA, one of our professional organizations. So what are these changes, changes that the Home Office have enacted? Well, I'm going to cover two main changes. First, since August 2023, late applications now entail a two-stage process, where basically the applicants needs to show reasonable grounds for missing the deadline before their eligibility can be assessed. So basically, the caseworker, the Home Office caseworker, when receiving a late application, will not assess the merit of the matter, but will have to consider whether the applicant has reasonable grounds for missing the deadline. And this means that a certificate application will not be issued until and unless reasonable grounds are found. So you see, the person will not have any temporary protection and will not be able to work. Or if the person needs to receive medical treatment, he will have to pay. If no reasonable grounds for missing the deadline are found, the application will be rejected as invalid. It won't be refused, but will be rejected as an invalid application. This means that the person will not have right to appeal or even the right to lodge an administrative review. The only way to challenge a decision of invalidity is a quite complex process called judicial review. But actually, there is good news on this, and I will mention later. Also, just to make clear, there isn't a definition of reasonable grounds in the law or in the guidance. So it's really at the discretion of the caseworker. Secondly, a number of grounds which existed in the previous version of the guidance have been removed. So there were, as you can see, I put out some examples, many cases where people, for instance, where applicants have been unable of the deadline. I've had many clients, South African, for instance, spouses, clients who were spouses of European nationals who had lived in the UK with their family for many years and who didn't know, were not aware that they had to make an application. So people who came to me and said, well, but my wife, she's Polish, she's French, she applied, but I didn't know I had to make an application. And that people will have become overstayers in the UK on 1st of July 2021. Or, for instance, the Home Office approach was quite lenient towards those applicants who did not have, or stated they did not have access to a computer, or could not speak English very well, or, for instance, overlooked the need to apply before the deadline, or maybe were not in the UK at the time. They were maybe working or studying, and they didn't know that an application under the scheme could have been lodged from outside the UK. So all of these examples have been removed from one day to the other, to be very honest with you. Luckily, and that's the good news, luckily some corrections to this approach have been, were made in just 3 weeks ago, over 3 weeks ago, in the latest guidance. I believe that the Home Office have received so many complaints that probably they thought it was a good idea to to amend, to change the guidance. And a new set of examples has been added now to the guidance. It doesn't mean that if an applicant falls within these categories, this new set of circumstances, they will, their application, the late application will be accepted. However, there is now, obviously, we have an indication that if someone, for instance, is a first-time applicant to the EU settlement scheme and has a valid residence document issued by the EA under the old EA regulations, that person could have reasonable grounds for missing the deadline. Or, for instance, if someone has lived in the UK for a long time, they've established strong ties with the country, or someone has an EA national spouse, for instance, or a partner who made an application and an in-time application under the scheme. And again, as I mentioned earlier, believed that they could not apply, they were not required to apply, and they had a valid document, a valid residence document. I've had many cases since 2021, since July 21, many cases where clients are non-European nationals who were issued with permanent residence. So maybe they were married, or they are still married to European nationals. They've been living in the UK for many years, and they perhaps applied for British nationality. They thought, well, I have permanent residence, I've held it for a good couple of years, I now would like to apply for British nationality. And of course, their application was refused, and they just realized that they were overstayers, they are not lawful status in the UK. This person now could have reasonable grounds. Again, if perhaps it's the first time he or she lodges an application under the scheme. Also, many non-European nationals had residence cards which seem to be valid. They say permanent residence. They have an expiry date perhaps of July 2024. So the person would say, well, but I got permanent residence. I got a document, a biometric document, which is still valid. Surely I have status. But unfortunately, that's not the case. If an application for to convert permanent residence into settled status wasn't made by the deadline, that person will have become an overstayer and the card won't be valid anymore. However, there are also cases where client say, well, but I had this card, I never applied for settled status, I had permanent residence, I've been in the UK for, let's say, 10 years, but I managed to travel in and out, I've never been stopped. So again, in that case, that's one of the examples in the new guidance, in the new version of the guidance, which will allow this person to have a valid excuse for missing the deadline. Or another very interesting example, many of my clients have reported that they received incorrect advice from employers, landlords, or the Home Office, or previous or other immigration lawyers. So I had this lovely guy, he was a South African client, married to a French national, to a Polish national. And I think just before the deadline, he asked his employer. So he exchanged correspondence with HR within the firm he was working for. And he said, well, do I need to do anything? And he was told, no, there's nothing for you to do. You are not a European national. This scheme is only open to European nationals. And of course, this was a wrong advice. But another client, for instance, reported that she was told by the Home Office to submit an application under a certain category, which was not correct. It was an incorrect category. Or again, an immigration lawyer incorrectly advised another client. Of course, you need proof. So I had, in this case, for instance, proof that the client had paid the lawyer. She had then complained and got a refund. So I could prove the wrong advice given by the immigration lawyer. So what to do if an application is refused? The applicant will have right to appeal to the Immigration Tribunal within 14 days or 28 days, depending whether the person is in or outside the UK. If an application has been rejected as invalid, remember there isn't any right to appeal, but only right to submit a judicial review. The first step to lodge a judicial review is to send a document called pre-action protocol to the Home Office within 90 days of the decision or receipt of from receipt of the decision. And from what we know, and we have been told by charities or other professional organizations, the pre-action protocols have been successful at restating applications. So if tonight we have people who have lodged a late application and I received a decision saying, well, sorry, no, you do not have a reasonable ground for missing the deadline, you do have a chance to have the applications restated if you are eligible to apply under the scheme. Perhaps you've lived in the UK for 5 years. If the deadline for an appeal has passed, so an appeal for a previous decision, you could consider whether lodging an out-of-time appeal. Perhaps you had a good reason for missing the deadline. Or perhaps a new application can be submitted. Just be very careful, because repeat applications are complex matter. So you really should seek legal assistance when possible and have a very good reason for missing the deadline and for lodging a second application. Or there might be other options. Can you apply as a family member, or maybe under a different category of the immigration law? So I hope if you have questions, please put them in, just write them in the Q&A. And I'll now pass the floor to my colleague, Dirk.
Yeah, thanks, Chiara. All right, guys, let me just share my screen with you. Let's see, it is probably this one. All right, let's just now focus here. Okay, all right, guys, so what I'm going to share with you tonight is, well, the options that is not going to be affected by all of this new kind of changes, the uncertainty we have at the moment. The effect that this is going to bring us is going to offer us a differing way to the UK, and I'll run through very briefly 3 specific ones, which I think is flexible, it is a better way for people to do business in the UK, and can potentially, lead to something else for you in the UK. So in my one, it's quite aptly called It's Only Business, and we will be specifically looking at the Innovator Founder Visa, the UK Expansion Worker Visa, and the Global Talent Visa. So if we get to it and we see why are we looking at these options. So as I said at the start, these options are all largely unaffected by the new rules or the proposed new rules that's going to happen. That's at least for the moment, as you all know, can change in the future. These options would give you the opportunity to swap to another visa in the UK. All 3 of these will. That's of course a choice of your own, and also only if you would qualify for something else whilst you're in the UK. Most of these options that we're going to discuss, or in particular the Innovator Founder and the Global Talent Visa, is going to offer you a bit of flexibility in the UK. And that's also going to be based off the fact, or let's call it rather your intention of what you want to do in the UK. Then, once again, Global Talent, Innovator Founder may offer you a faster route to settlement in the UK. And when I say settlement, this refers to your permanent residency status, which can normally, under most of the route, only be granted after a 5-year continuous period of 5 years in the UK. But something like a Global Talent or an Innovator Founder may grant you the expedited option. And then all of these options are going to offer business-minded people a lot of, like I said, it's got flexibility and also the opportunity to kind of branch out and do business in the UK. And then lastly, some of these, which I'll briefly touch on as we go through them, is going to take away the need for certain requirements to be met at the start of the process, the entry clearance phase, which is going to be your first visa. All right, so first up, Innovator Founder. One of my personal favorites, so let's briefly look at what this route means for us. So the Innovator Founder is a great opportunity for all business-minded people, entrepreneurs, to get to the UK and establish a business presence in the UK. Previously, this kind of category was known as the 2 separate ones, the Innovator category and then the Startup category. Before that, it was also the Tier 1 entrepreneurial visa, but lot more changes was affected between the entrepreneur and the innovator than the changes affected between the innovator and the innovative founder that we're discussing now. The changes that we have on the innovative founder is very beneficial to the applicant. If I can briefly touch on those changes, right? So the first thing is, under the normal innovator, or the previous innovator rather, you had a requirement that you had to invest £50,000 of your own money into the business. All right, that's no longer a stringent requirement, but in the next slide, I'll briefly touch on something that we still need to keep in mind when we look at how much money specifically you need to take over, or you need to have to establish your company in the UK. The other change, of course, that was affected, which is the major one, is that you are now allowed to do additional skilled occupation or additional skilled work in the UK rather. So previously we had the scenario where you could only work for the company that you established under the innovator visa. Now, under the innovator founder, we can do additional work for other companies, provided that it's skilled work. And then, as I referred to in my previous slide, this does offer an expedited route to settlement in the UK, to your permanent residency. There's a lot of stringent requirements that needs to be met in order for you to get that expedited route of settlement. But after 3 years of your grant, you might be able to get that, which would be kind of a beneficial thing, especially for business people that doesn't want to be tied down in one place for too long. Then I briefly want to touch on the endorsement aspect of this as well. So the main thing to realize rather with the endorsement stage is it is a strict but achievable process. All right. So the endorsement body that we apply to is going to consider 3 pillars here. It's going to consider innovation, viability, and scalability. Under innovation, we look at things like, is this something that exists in the UK market in the moment, or is this a totally new thing? The second thing we're going to be looking at, or that the endorsement body is going to be looking at, is under the scalability route. Does this business have the prospects to scale itself in the UK, open up additional let's call it shops, additional outlets in the UK? Can we go overseas with this business as well? And when we look at scalability, we also need to prove that how much funds we're going to invest in this business. So if I can take the example, if you're going to be starting a manufacturing plant in the UK, and this is your business, you can't come to them and say, I have £10,000 ready and I want to start my manufacturing plant. Of course, you need to provide, under logical business sense, that the funds that you have is going to be applicable and it's going to allow you to start this business in the UK. Then if we look to the last one, the viability aspect of this, also, once again, they're going to how strong is your business plan? Are you capable, you as a person, the innovator, capable of doing this business in the UK? Will this business take off? And this is also where a lot of market research is going to come in. Have you scoped? Have you seen what's going on in the UK? So those 3 elements will be assessed in very big detail, and it will go back to the core of your business. So that's why it's a very strict, let's call it, endorsement process, but it is achievable with the right planning from the start, and it's really something that's going to offer you with a great opportunity in the UK. Other changes that we had is there's 4 business endorsement bodies left. Previously we sat with about over 40, if I'm not mistaken, endorsement bodies, and that led to the scenario where we couldn't really, or the Home Office couldn't really control what was going on there. Now we're sitting with 3 or 4 endorsement bodies, and all of them have very strict regimens, that they need to follow. They need to check off this, they need to check off this, they need to check off this. The process has now been made exactly the same through all of them. So you apply in the same manner. And then, of course, you only pay a specific endorsement fee, and they're not allowed to charge you more at the start. Whereas previously, we had 40 endorsement bodies, each charging their own fees, and it sometimes became an exorbitant amount that you would be charged there. So I'll end off the innovative founder with the fact that, it's still if you get endorsement, you go for the visa, the entry clearance stage, and that is still a tricky one in itself. So just because you got the endorsement does not mean you're going to get the entry clearance as well. It's a very fine line that you need to navigate there, and it requires a lot of input. But it's really a straight line from there if you do everything right. And very important, it's not only for tech. A lot of information out there is going to tell you it's for tech. Don't even try this route if it's for tech. That is not the truth at all. It goes back to those three pillars: innovation, viability, scalability, and we need to prove, that your business is something that's going to be new in the UK in the sense that it doesn't exist, or it's going to create a competitive market advantage. Second, we're going to briefly touch on the expansion worker visa. Now, the expansion worker visa is something that took over from the representative of an overseas business visa. I don't know, if you've read about that, but it's not applicable anymore, so I'm not going to go into that at the moment. Likewise, to something like the innovative founder, the changes that was made to this visa is very beneficial to the applicant, in the sense that under the old rule, or under the old representative of an overseas business visa, you could not have owned more than majority of the company for you to go over to the UK. All right. In this iteration of it, it has been removed in its entirety. So if we look at what the expansion worker essentially is, to its core, it's if overseas businesses, meaning a business outside of the UK, wants to start some trading in the UK, or they want to gain a presence in the UK, you can apply to establish a wholly owned subsidiary or a branch in the UK of that overseas business. All right. It's a 3-step process, whereas on the previous iteration, it was one big application and that's it. Now we have a 3-step process, which is a lot like the skilled worker in the sense that we have a sponsor license application, we have a certificate of sponsorship application, and we have a visa application. All right. This visa is going to grant you 2 years in the UK to establish this business, but the good thing about it is it gives you the potential to swap over to something like a skilled worker at the end of that 2 years, provided that all the rights, as with everything, all of the red tape's been followed, all requirements has been met. It is something we can do. Lastly, there's a lot of rigid rules we need to meet here, but in that rigidness of the rules, it's also kind of structured. If you can tick off and meet all of the requirements, it is a good route to follow. Then finally, quickly looking at the Global Talent Visa. Global Talent Visa has been around for a long time, previously known as the Tier 1 Exceptional Talent Promise. So we still have that. The Global Talent offers a visa for leaders in their field, which has exceptional talent or promise, meaning people that's emerging leaders in their field. All right. This is also a 2-step process. You apply for endorsement to an applicable endorsement body, and then you go for the visa application on the second roll. You can apply to this for the endorsement if you're a leader or emerging leader in either digital technology, arts and culture, or science and academia. And it's important to note that each and every one of these have their own ways to meet the requirements and how you can apply to. For instance, if you go with the digital technology option, you can either be a business applicant or technical applicant. If you go arts and culture, you can either do film and television, you can do, I believe, architecture also falls under that. So there's a lot of options that we can explore there. The best thing possibly about the Global Talent Visa is the flexibility that it's going to offer you. It's a massive flexibility. You have full right to work at any company that you want to in the UK, meaning you don't have to be sponsored, such as on the skilled worker. You can essentially start your own company, you can do whatever you want to, and at the end of the day, you need to prove that you just did some work in your endorsed field of talent. This also grants an expedited route to settlement, indefinite leave to remain or permanent residency after 3 years if you've been endorsed as an exceptional talent candidate in certain routes. And a final point I want to touch on is this can also be combined with other routes. Take the scenario where you've been on the skilled worker for a 2-year period and you now go over to the global talent as an exceptional talent candidate. You can merge the time that you spent on those two. in order for you to get permanent residency at the end of the day. So as you can see, Global Talent offers a lot of flexibility, not even mentioning the fact that if you endorse this Global Talent, kind of, tap on the shoulder for you there. So one of the good ones, and something to consider, moving forward. All right, so those are the three that I had to discuss with you guys today. So thanks for listening. I'm going to hand it over to JP again for him to take us further into the Q&A.
Yeah, thanks, Dirk. Appreciate it. Chiara, if you and Verity can just join us again so we can do the Q&A, then I would be grateful. Thank you, everybody, for the questions. I think maybe just to start off, I just sort of want to mention two things as well. One of the things I want to mention is, and we're going to do a separate webinar about it again, is the whole nationality thing. With Section 4L having been brought into the 1981 Act, and things you guys might have heard, ARD applications, UKM applications, all these sort of weird and exotic new routes that's available. The applications are taking a very long time to be processed. Some of the applications, it would appear, given it's so new, the Home Office don't know what to do with it, and they sort of keep on to those applications for some time. So if you have an application pending, please just be patient. They will get to it eventually. And we will do a separate sort of an update webinar on that quite soon, because there's a lot of things that have changed and a lot more clarity that has been provided over the last 6 months or so. The other thing I want to touch on first also, before we get to the Q&A specifically, is the new financial requirements for settlement on the spousal route as well. I know that's giving a lot of people a lot of stress. Chiara, I know you also deal a lot with this, so please do feel free to chip in. But the basic idea is that the base amount will increase. Currently, for a single applicant, it's £18,600 that the British citizen had to have earned prior to being able to sponsor the foreign national as their spouse or partner. That's an oversimplification. There are quite a few different ways of meeting the requirement, including non-employment income, cash savings, pensions, and so forth. But the base amount of 18,600, that's changing, and it's changing, we think. So again, as Verity so kindly pointed out earlier, none of this is set in stone, but in all likelihood, on the 11th of April, that's going to change to £29,000, as opposed to 18,600, and that will then increase later on to 34,500, and then eventually to 38,700. Apparently, that's the figure the government came up with. So we'll see how all of that plays out. What is important to note, there are always ways and means if one can give enough time to apply one's mind to a problem. It doesn't mean that if you don't earn that money and you want to sponsor a partner, that it's never going to happen. There are quite a few different things that one can take into account. Human Rights Act still applies to an extent, and there are various exceptional circumstances as well. So if you have any queries about that, please reach out to us. You can reach out to info@bic-immigration.com or to me directly, which is jpb@bic-immigration.com. I know it's super stressful at the moment for a lot of people. If you can, get your application in before the 11th of April. If you can't, please talk to us. Let's make a plan. And we can see what we can do. Now, going over onto the actual Q&As, Verity, I'm going to sort of ask you to answer or deal with the first one from Anonymous about the caregiving route. It says here, it seems a lot of companies, even those registered as sponsors who have sponsored before, are no longer offering sponsorship for eligible roles. Why? Is the UK sort of cracking down on those specifically? What your input would be there?
Yeah, absolutely. Unfortunately, and again, it's things that people may have seen reported, particularly if you live in the UK already, you may have seen quite a number of reports of care providers who are legitimate sponsors. They have sponsor licenses, offering employment to people and then coming over and when the migrants arrive, not making good on those promises. And there's been some really brutal, shocking stories of people being, left stranded homeless in the UK with no way of getting by. As a result of that, unfortunately, it has brought the whole of the care industry. There's plenty of genuine, legitimate providers who are, still sponsoring new workers. But yes, it's a lot trickier We're seeing lots of delays on applications for certificates of sponsorship for care workers, lots of requests from the Home Office to provide further information to justify. So it is absolutely an area that's under a great deal of scrutiny from the Home Office at the moment, unfortunately.
Yeah, we also saw a successful judicial review, one of the first ones not too long ago, didn't we? So industry is sort of, I want to use the words fighting back, but watch this space. You know, the government can't just do what the government wants to do, especially given the state of the economy.
It's a small number of people, as usual. You know, the bad apple rots the whole cart. The Home Office is looking at everyone. I mean, all of the applications we're dealing with, they're all still being approved. You know, everything's still coming through. It's just, it's got to be done properly because they are under the microscope at the moment.
Yeah, absolutely. And on that point, and to your point, Verity, just something else to mention, for example, the sole representative visas for the extensions, the few that are still left on that route and the indefinite leave remains. Please be incredibly careful. The Home Office are looking at those even more strictly than they used to. We're getting some ridiculous questions, tier one entrepreneurs, because they're routes that are closing. Please do get professional help with those. Otherwise, they really are quite likely to be refused. Nicola asks, if you've been in the UK on a health and care workers visa for 2.5 years, will the changes apply to you when you want to extend the visa?
It's not as of yet been fully confirmed. Based on previous experience, I imagine that it would be. You know, if you're on the visa, say you come in, you get the visa the day before the increase to salaries take place, you will be able to stay for the validity of the visa on the salaries that were agreed, subject to things like national minimum wage increases, which always have to be met. But we don't know for sure, but it seems relatively likely when they extend the visas, it will be the new rates that will need to apply. Bearing in mind, though, health and care visas are ones that are going to be exempted from this 38,700. I expect that the minimum rate for them will increase, but it's, so far as we know, not going to go up to the 38,700 for care workers, health and care workers or educational positions.
Yeah, and we'll have to see how that's being dealt with. You know, one could argue they're moving the goalposts, the general expectation, all that jazz. You know, we saw this before with the HSMP forum case. You know, so we'll have to see what happens there. Helen asks, can you get settlement status after 5 years if you go to the UK this year as a care worker, Verity? I can't see why not if you stay on the route.
Luckily, there's no changes to the indefinite leave to remain sort of processes. It's just to do with things like salary rates. So anybody coming to the UK on any kind of skilled worker visa, health and care or otherwise, will be able to qualify once they've completed 5 years in the UK, provided they've done what they're supposed to do. So, you know, don't travel too excessively, don't commit any crimes and so on.
Yeah, never commit any crimes. That's never a good idea if you can help it. Paula asks, for skilled worker visa, would the minimum salary of 38,700 be applicable to those careers on the skills shortage list?
So the shortage occupation list position is being replaced with this immigration price reduction. Sorry, I actually have to check more. I've completely blanked on what they've called it. The immigration salary list, the immigration salary list. So far as we know, anything that's going to be covered by the immigration salary list will be exempted from the 38,700 minimum. We don't know what's going to be included on that list yet. That's still being reviewed by the Migration Advice Committee, the MAC. So we're still waiting for their recommendations. But there's a good chance that a lot of what's on the shortage list may end up on this. It seems to me like a rebranding, very similar to when we left the EU, when we went from a skilled worker visa, from a tier 2 general to a skilled worker visa, because Parliament likes to make it sound like they've brought in something entirely different because it sounds good to voters. So I wouldn't be surprised if actually what we end up with is effectively the same thing as what we have at the moment, just relabeled under a different name. Hopefully we'll have more information by mid-March. That's you know, what the Home Office are targeting for when they're going to get us more information on these finer details.
Yeah. Anonymous asks, this is something we're getting quite a bit at the moment. So my husband moved over to the UK, was able to get his British passport. I'm South African. His current salary is 28k annually. we have to go to the route of him working for 6 months before I can apply for the spousal visa. Now, after the new law starting at 29K, how will this affect my application? Well, it's going to depend on when the 6 months is up, of course. And also it's going to depend on whether or not maybe he can work part-time. You know, this is something really you need to reach out for us, and we can hopefully sort of help you guys plan on that. But technically speaking, if he's not going to make the 29K, somehow he's not going to make it. So please do reach out so we can see if we can't assist you and him somehow to plan things in advance to get you guys there.
JP, can I join in?
Of course you can, please.
Because obviously I receive many of these questions. As you would say, it's really, really important to have a consultation because, you know, there are many ways in which the financial requirement for the spouse visa can be met and people don't know. Also, this person did not mention any children, but good news, the £29,000 requirement, remember, does not include children. At the moment, yes, the minimum requirement is 18,600 if you want to sponsor a partner. But if you have children, non-British, non-settled children, obviously the requirement increases, right? But with the new rules, children are included. Also, there could be a way, for instance, to, let's say someone is in the UK and the person does not meet the requirement. So I guess the person will ask us might still be outside the UK, right? She hasn't joined her husband, but there might be ways to lodge a different application and to buy some time so that the sponsor can complete a 6-month period and then vary the application into a spouse application. And this is absolutely lawful, but again, it's not something we can just quickly explain today. So a consultation is really, really needed. Also, there are some types of benefits which the British or settled sponsor may receive, which can massively help in demonstrating a different financial requirement, meeting a different financial requirement much easier, not the £29,000. So again, that's something that you could consider, or having British children, or perhaps if there are applicants with serious medical condition, the Home Office could exercise discretion. So there are ways to go around these, but again, it must be assessed on a case-to-case basis.
Thank you, Chiara. Emily's got an interesting question. My South African husband was a permanent resident in the UK until 2009. She's British. 2 oldest kids were born in the UK, so of course British by birth. 2 were born in South Africa. We have not returned to the UK since 2009. Our family still lives in the UK, but we don't have any other strong ties. Do you think there's a chance for a returning resident application? What are the approximate costs involved? In terms of costs, that really does depend. We don't discuss costs really on here because it's kind of pointless. It depends on a million different things. But the question itself is interesting. Chiara, you want to have a stab at it?
Yes. So the first question I will ask is what was the reason for leaving the UK? And have you come back? So have you left the UK since 2009 without ever coming back? So these are very important questions, key questions, I would say. But it's not, obviously, if they haven't come back, maybe they just decided to leave the UK and live elsewhere, it might be difficult to lodge a returning resident application. However, we had cases, very similar cases, and we have successfully applied for a returning resident visa. But it really depends on the reason why the person left the UK and what happened since they left. There were any particular reasons why they couldn't come back. COVID, of course, we know COVID was one of the reasons why many residents, people who have been long-term residents of the UK could not come back. But there might be other reasons, maybe illnesses, maybe someone, a family member was not well, so there was the need to care for the family member. So yes, it is possible, but again, we need to have more information.
Just to add to that as well, as I mentioned, these changes, very, very recent, this change to the rules that's made it seem like this is even possible. As I sort of suggested earlier on, unfortunately, because they're so very new, we have very little context from the Home Office as to how they're going to apply this. I mean, we don't even have overt confirmation that we've understood correctly. It's just that is how you would read the law, how it now stands. So what I would say is, sort of tentatively with this one, we kind of need to watch this space a little bit and wait for the guidance to be released so that we can see if they're giving us any further clarification on what exactly they mean by strong ties to the UK, whether family would be sufficient or whether they're expecting to see something more. So hopefully something we'll be able to provide better guidance on in the coming weeks when the associated guidance is released.
Yeah, and also just another thing, Emily, obviously your 2 kids, and I'm presuming here, and we know what that leads to, but so do reach out to me so I can just confirm. But effectively, all the kids born in the UK, I would imagine, are British by birth, depending on how you got your citizenship. But the 2 born in South Africa, they might already be, otherwise they might be able to be registered as British, depending on their age. Of course, if all 4 of your children are British and going to live in the UK, that'll strengthen ties enormously. So reach out to us. Let's see. It seems like a strong case in the face of it, but as Verity says, watch the space and let's get more details. I'm just going to run through some quickly. I see we're almost up to an hour. Chiara, I see you're answering Kevin, who asks, "Can my wife join me in ancestral visa?" Short answer, yes. Ancestral visas are allowed dependents. So yes, and Kevin's follow-up question, can she do care work? She can do whatever work she wants to do. She's not, there's no sort of let or hindrance, that she needs to do. Of course, she needs to do criminal records checks and all the kind of things specific to the industry she wants to work in. But yes, she can. Anonymous asks, I'm a UK citizen living in South Africa, intending to move back to the UK, wife, 2 kids, South African. Any changes need to be made aware of? I think the changes that we've discussed, there's nothing really, well, at the moment, that needs to be taken into account. It'll really only be the financial requirement, which wouldn't be that far off if it goes to 29 to what you'd have to prove anyway with a wife and 2 kids. So the impact shouldn't be that severe on you.
JP, sorry to...
Yeah, go.
Very interesting question, Anonymous. So is there a cash savings alternative to the salary requirement when I apply for ILR on a spouse visa? Before I answer this question, I just want to, maybe remind some people that if you rely on savings, though, at the ILR stage for a spouse visa, you only need £34,600 and not £62,500, which many of my clients were very surprised to hear. So that perhaps can help. At the moment, if you have any children, well, that level of savings will go up. But yes, there are, of course, other alternatives to the salary requirement. If you apply for ILR, there could be sponsor employment, salary employment. If the sponsor is on benefits, then again, the requirement may be different, or pension, or rental income. So there could be different ways to satisfy the requirement. But I just wanted to mention the different level of savings required at the ILR stage, because many people don't know. The majority of my clients do not know, have no idea. They still think, oh, but I need £62,500. No, you don't. You only need £34,600 when you apply for ILR, until April, of course.
Yeah, thank you, Chiara. There's a couple of questions sort of revolving around the cash savings. So thank you for addressing that. Interesting one from Mark, just briefly. Whilst BRP expires in July, Mark, I presume that is on a current leave to remain as a spouse, applying for the extension in June after the 5 April increase. Would the increase affect him effectively, I suppose, is what we're asking here. So if you're already on the route with the extension, would the increase affect you? Chiara, what do you think? I don't think so.
No. From the information we have received from the Home Office, if someone already holds a spouse visa, so they applied obviously before, the new changes will not affect them. So they will still be required to meet the 18,600 requirement. Yeah. So no.
So far, yeah, this is what we're thinking. Yeah.
So far, exactly. The Home Office like to change. They give us very short notice, but so far that's what they said, and it makes sense. So it will be a transitional regime. But so far.
Thank you. There was also another question that I can't find very quickly, but the facts effectively related around a gentleman who asked about his son, who has children in the UK, whose mother, and they live with the mother, I believe. I don't know which one of you want to tackle the family life as a parent quickly. Chiara?
Yeah, so so from my understanding, the daughter, so I lost the question, but yes, so the children are British in the UK, and the father is outside the UK. He has a visit visa, right? And the key question is the father in a relationship with the children's mother? I'm trying to find the question. If they are, so if the parents are in a relationship, then the correct category will be the spouse or a married partners, the same category, spouse visa. When we refer to the spouse visa, the category is actually partners visa and includes spouses, civil partners, or unmarried partners who usually have lived together for 2 years. However, having a child, and in particular a British child, is a bonus, let's say. So even though the parents have not lived together for 2 years, the father could apply for a parent's visa. If the parents are not together, then the correct category for the father to enter the UK will be to make an application under the parent of a child of a settled child visa. Okay, so there are two options. It depends whether the parents are together. If together, then the partner's visa application is the answer. If not, then the father can apply for a parent of a child visa. And he will be able to settle after.
Yeah, it's a very interesting route. Not a lot of people know about it. It's effectively to protect the rights of both the child and the migrant parent, for that parent to be able to live in the UK and play an active role in that child's life. So the key thing is to play an active role in that child's life, get permission from the other parent, or get a court order giving you permission to actually see that child and be involved in that child's life. I think we're going to do two more. I don't know if there's anyone that sort of jumped out at you guys. Dirk, I don't know if there's anything you want to specifically. You've been very quiet, unusually so. Anything that you want to address briefly?
Yeah, I think there's one, JP, specifically that I noticed. Someone that consulted with you quite a while back, there was a majority stakeholder in his business at that point in time. Now, quite correct in terms of the new, iteration of which was the representative of the overseas business visa, now the UK expansion worker. That majority rule has now been removed in its entirety, So there's a lot of other red flags that we need to avoid and kind of red tape that we need to go through. But sure, I also note that person asking the question is on the graduate visa at the moment. Tricky scenario from there to there's certain instances where you can't switch into this visa from the graduate visa. So that's also something that I would advise, reach out to us, because although these business routes really offer flexible and kind of good ways at the moment, it's something we can't miss small details in that. So reach out to us and let's rather discuss that in a bit more detail.
Yeah, but things have changed. It's really worth looking at it again, definitely. Then two more questions. The one question is from Denise and Charles. All BRPs expire end of this year. My letter with my BRP stated expires next year in July. When do I apply for my ILR? Verity, you want to quickly address the new e-visas and why the BRPs expire end of this year, please?
Yeah, good choice. I was going to suggest the same one because I suspect this is something that people, if they haven't noticed yet, will be noticing soon. So yes, at the moment, nobody is being issued with a biometric card that goes beyond the 31st of December 2024. That is not when your permission to be in the UK finishes. Unfortunately, at the moment, you need to go back and refer to your approval paperwork, which will give the exact dates that the visa is valid. Likewise, you may be able to get your online status. If you can't put your hands on that, you may be able to get your electronic status online. The reason for that is the Home Office is moving to a purely electronic system, or intending to, from the start of January 2025. So nobody will have biometric cards. Nobody will have physical visas, so far as we're aware. The Home Office have said they're going to update us across the course of this year as to how this new system is going to work. So at the moment, again, we don't have very much information other than this change is coming, and they will tell us about it soon. In terms of qualifying for indefinite leave to remain, though, in the vast majority of visa routes, including skilled workers, spouses, many others. There are a few niche examples, a few niche exceptions where you don't need to do it, but usually speaking, you need to complete 5 years in the UK in your visa category. So 5 years living in the UK as a skilled worker, or 5 years living in the UK as a spouse of a British national, for example. So it's not necessarily tied in with your expiry date on your biometric card. You'll need to check actually when you got your initial visa and then add 5 years to that.
Thank you. And then, Verita, I'm going to finish with you as well, because this is something we're getting a lot of that concerns me a little bit. Anonymous asks, can I go on a self-sponsorship visa or a skilled worker visa and sponsor myself?
Okay, so I will try to keep this brief. This can often take me a good 20 minutes just on this topic in a consultation. So technically, yes, what people refer to as self-sponsorship is technically viable. What people are referring to when they say that is somebody who owns their own business in the UK, who's the majority or 100% owner of their own business in the UK and is looking to sponsor themselves as an employee through their business. Now, yes, it is correct that there are no restrictions on how many shares a person owns in a company if they are going to be sponsored on one of these, well, on the skilled worker visa specifically. So yes, technically it is possible. What we have to be very careful, and unfortunately there are lots of law firms out there that seem to be advertising this as a very easy option, and it is simply not. It is possible, but there is a lot that needs to happen. Just to give you a very brief, really rough idea, for a start, you need to have at least one member of personnel already working for the UK office, either a director or a pay-as-you-earn employee who understands how the business works, who can answer any questions the Home Office might have, who can justify why the company needs to hire you, even though you own it. That person has to be British or settled and relatively senior usually. So it's not a case of just opening a company and then applying for a visa. You have to have this personnel in place to be able to actually get the paperwork in place for the company before you can go and apply for a visa. There's numerous other considerations, difficulties on opening a British business account, which you have to have if you're applying for a license within 18 months of the company being incorporated, financial viability. We have to satisfy the Home Office that this is all genuine and not just an attempt to get a certain person into the UK. As I say, I don't want to bore everybody for the rest of the evening on the myriad of factors that need to be taken into consideration. In short, it is possible. It is not easy. If it's something you're planning to do, please do reach out to us, because we've got a fair amount of experience. But as I say, it's not quite the walk in the park that some companies are making it out to be.
JP, if I could quickly, perhaps just one or two sentences on that now. I'm sure Verity will agree with me. We've discussed this ad nauseum over the times. I think the two very important points to consider there is, number one, there is no such thing as a self-sponsorship visa. I think we should get that right. There's a lot of people advertising this is a self-sponsorship visa. There is no such thing. It is an opportunity, and it's viable due to the fact that you follow normal skilled working rules and principles. Sponsor licensing and then skilled worker. But once again, you need to adhere to all the rules. So just that's my 2 cents based on that.
Absolutely. Yeah. Thanks, Doug. Yeah.
Thank you, guys. Yeah, just be careful. The thing that concerns me is there's a lot of companies and firms sort of trying to sell a product where you self-sponsor. There's no such thing. Please be super careful. They oftentimes cost a lot of money, and if you look at the fine print, there's no guarantees, and more often than not, they don't work. And one also has to appreciate the Home Office's stance on this. The Home Office's intent behind allowing you to own 100% of the business and being a director of that business and still being sponsored is not so you can self-sponsor. It's just to make it a bit more viable for businesses to actually get established and sort of move on in the UK without it being the case it used to be, where you could generally only own 10% of the business unless you earned substantially high salary. So just word to the wise and all that. If it's too good to be true, tend to be. And once you're caught out and the Home Office don't like you, they're not just going to start liking you, and it will make your immigration journey a lot more complicated moving forward. So unless my esteemed colleagues have anything else that they want to discuss, then I will thank everybody very much. And Jacinda behind the scenes, thank you as always for being the brains of the operation. And to all our clients, thank you very much for attending the webinar. Please, guys, if there's anything, just reach out. And if you don't want to reach out to our info emails, email me directly. Again, it's jpb@bic-immigration.com. Please don't take any chances. Please reach out and have a lovely evening. Thank you, everybody.